Thank you. And thank you very much for setting this up. Like I said, like was introduced, my name is Jacob Vella, and we're going to be talking about generative AI today. So by way of introduction, we're going to start with who I am because I think that gives a little bit of context to where we're going. So I'm a lawyer, first of all, and I have built my firm on helping artists with their intellectual property, contracts, and business needs so they can focus on creating things. I am also a creator, which is largely what inspired that. I make video games, and my first major release is hopefully going to come out this July. And I've been thinking about AI in creative works for a very long time. So when I was in high school, I had to write an extended essay as part of the IB program, and I chose to write about the question of whether or not computers would ever be able to compose music. Because, I was a band kid, I was really into computers and coding, so this was the logical choice. This was all the way back in 2010, and the landscape has changed pretty significantly since then. Back then, the same methods that were being used by AI models were already in use. The ones we're using today, they were already being used, but they were being used at a very different scale. And there was some very big differences in terms of how the intellectual property concerns worked back then versus now. And we'll touch on that as we go forward. So this is what we're going to talk about. We're going to talk about what copyright is and why it matters, because that gives context to everything we're going to talk about. We're going to talk about how generative AI works, and it's going to be a pretty basic explanation given the amount of time we have here, but it'll be enough for our purposes. With that understanding, we'll be able to talk about the legal issues surrounding generative AI and some of the consequences and questions that we'll be facing as we go into the future. An important thing to note as we move through this technology is still very much in its infancy. Anytime I use an example or you see an example out there and you think, oh, it's not such a big deal, remember these models will only get more advanced over time. And these are questions that are worth grappling with now. So let's get into it. Copyright. So the core idea behind copyright is that making something takes a lot of work. And if you've created something, you know that's true. But once you've created it, making one more copy is relatively easy. So we want people to create art, so we incentivize its creation by protecting it. We secure exclusive rights for the creators of creative works. That could be music, that could be art, that could be games, that could be videos. Anything creative, we can protect it. Anytime it's fixed into an expressive medium, we protect it. Copyright protects the expression of these ideas, not the ideas themselves. And it is not the right to create something or do things with your work. It's not like the government stamps of approval. Yes, you can make more copies now. No, it's the right to prevent others from using your work at the most basic level. It is the right of reproduction, the right of distribution, the right of public performance and public display, and the right to create derivative works. Those are some of the copyrights that are invoked that you have, but those are probably the most important ones for what we're going to be talking about today. You don't need to register your work to have a copyright protection over it, but it's generally still a good idea. Talk to your lawyer about that. The basic idea, and this is the important part, if you use someone else's work that is protected by copyright and you do not get a license, it is probably infringement. There are defenses to that, but at a baseline, it's probably infringement. So why is it so important? It protects your work. You work hard to make something, other people shouldn't be able to take advantage of it. I got this little graph, it takes a lot of work to create something. Every other copy is very little. Why should you put in this effort and somebody else can put in that little bit of effort? So it's more important now to understand copyright than ever because anyone can publish stuff without a publisher. I can go online and post a video on YouTube and publish work. Anybody can use copyright, but also anyone can infringe copyright in the current era. So it's very important to understand what copyright is. With that, we're going to talk about how generative AI works. And again, I'm going to emphasize this is going to be a very simplified and gross explanation. I'm going to explain at a high level, then we're going to talk about some specific applications. And if it's all sounds still super technical, don't worry. I'm going to do the really simple explanation at the end. You don't need to work out the details. So the first step is data is incorporated into a data set. Massive amounts of data are incorporated into just a big database, essentially. And it's usually tagged in some way. So all the pictures of an apple will be tagged as that's an apple. And the amount of data we are talking about here is absolutely massive to start. The Lion 5B dataset is something we're going to be talking about later on. It is about 240 terabytes or 5.85 billion images. And I tried to find a way to explain how big that is. And the entirety of Wikipedia, if you were to downloading it without any images and you didn't compress anything, it would be about 160 gigabytes. So we're talking this data set is about 1,500, 1,500 Wikipedias. So once you have that data set, the data is then learned. And I put that in quotes because it's not really learning in the way we do, but relationships between the data are incorporated. So if we're dealing with text, a model might learn what kind of words tend to follow each other in their relationships. So that if we're dealing with cookie recipes, it might say, oh, ovens, typically we're talking about 350 degrees. Okay. Usually the original data set isn't actually included in the model, but it's indexed and then it's used in some way. From there, the user prompts the data set, and that is used to call upon which parts of the data set it should be used on. So language models are used to decipher what the user is looking for. Is the user asking a question? What are they asking? What kind of results are they looking for? What kind of data should we be incorporating? And finally, for the output, it interprets the data set and depends on what sort of application we're talking about here. We're going to talk about some common uses, but it can take several different forms. So text generation is something that people are familiar. This is things like ChatGPT. It's trained on that massive amount of human created text. It can be scraped from the internet or from other sources. And we're going to touch on one of those later on. And then patterns are learned. A user's prompt is used to determine what data should be called on and what sort of text response it should be generated. And then new text is created or existing text is modified. I like this example personally. And I don't know if this will help you, but it really helped me understand how this works. It's dice. I have here in my hand 5 dice of different colors. If I was to roll them, I could reasonably predict what the outcome would be based on probability. But if I was to take some of these dice out of my hands and just set them down, and once I know some of the dice, I can more narrowly tailor what the answer will be. That's like the user's prompt. We can predict what is likely to be rolled based on what has previously been rolled. We have a ton of data. We can predict what the outcome will be. But what happens when the dice aren't all standard D6s? We start to work with strange dice like this D12. We start to have some weighted dice, some dice with different numbers, different values on them. Now we start to need a lot of data. And once we have all that data, we can once again predict. Yeah, based on past rolls, we can reasonably predict what's coming next. So extrapolating on this, there are thousands of dice, different numbers, different weights, but if we have a big enough data set, we can predict it. Another way to think about it is it's not magic, it's not intelligence, it's a word calculator. It is a very advanced sandwich finisher. It finishes your sentences and can predict what comes next. This is all only possible thanks to a very, very large data set. Let's get into image generation because it's a similar idea. Images are incorporated into a data set. Machine learning takes place. It's kind of cool, but they're blurred over and over until they become a pixelated mess. And then it gets really good at unblurring images. User's prompt is used to know which sets of the data set should be called upon. Oh, pictures of apples. I know what an apple looks like. And then a text encoder interprets the prompt and it stabilizes that diffused or blurry image, which is where Stable Diffusion, the name, comes from, is it's taking a blurry image and stabilizing it. I asked DALL-E Mini, this was years ago, so again, the technology has improved since then. This was asking for a car on top of a wedge of cheese, and it actually got most of the parts right. There is a wedge of cheese, there is a car, there is an on top of. It's just the order wasn't quite right. Something that needs to be understood here is that AI is seldom general purpose. It is trained on a specific task through lots of data training data. That is to say, it gets very good at unblurring images, but it can't do things they don't have training data for. So general AI or AI that can really do anything, there's a lot of talk about it. It's not actually realistic. And at this time, and anytime anybody tells you, oh yeah, we're creating general AI, you should think about what the data set would entail, because anytime anybody promises anything that AI can do this, think about the data set because it has to have lots of data to work. Here's the simple version. Data goes in, model uses that data to create something. Nothing is possible without that original data set. So I said at the beginning that copyright is kind of going to be something I want you to be thinking about throughout and will kind of underlie all these issues we're going to be talking about. And Now we're going to talk about the legal issues. And if you've been thinking about copyright, you might see one really big issue. And if your thought is, isn't that just infringement? Yeah, you're on top of things. You're paying attention, and I'm impressed by your question. So, is AI just mass infringement? Because they're incorporating other people's creative works, be that text, be that images, be that music, videos, whatever. They're incorporating it into this big data set. The question becomes, is that infringement? Because if it is infringement, these models now have to get a license or own everything that they're incorporating. And that is a lot of licenses and is very expensive. Sam Altman in the last, I want to say year, who is the CEO, the head of OpenAI, he said that it just was not possible without if they had to get a license for everything. And that really frames it, I think. If it's not infringement or if it is fair use to create these models, then AI companies effectively have free reign to do whatever they want with any data they can scrape off of the internet. Data in this case could include your artistic works. So yeah. Once again, I talked about the Lion 5B data set earlier, and that really frames how big of a data set we're talking about. Because when Sam Altman said, yeah, this probably wouldn't be possible if we need a license, I did some thinking about this. And this is a card from the game Magic the Gathering. It is Zoraline Cosmos Collar. It is the art was created by an artist named Justin Gerard, but Wizards of the Coast owns the copyright on it because they hired him to do it. It is a work made for hire. Wizards of the Coast as a company has been running this game for a very long time. There have been more than 27,425 cards in Magic the Gathering, with more added every couple months. So if they were to use everything that they owned and create their own in-house AI model, could they do that? Well, that would probably be an ethical use of AI. That would be an ethical way to create a model. Except they would, if they took all the art they've ever created and put it into a data set, they would have 0.0005% of what the Lion 5B data set is, or 1/200,000th of what was necessary to do Lion 5B. So it's not really feasible even for a big company that's been making art for a very long time. Now, so what I'm saying is an ethical, a legal, if it's infringement use of AI, it'd be really hard to create a model in this way. So the big question actually hasn't been answered yet. Courts are still very much grappling with these questions, and cases are kind of still working their way through the court system. So next we're going to take a look at a few of these cases. So the first one I want to talk about is Anderson versus Stability AI. So in this case, the plaintiffs are a group of artists on behalf of themselves and other artists. The defendants are Stability AI, Midjourney, DeviantArt, and Runway AI, most of which are AI companies, DeviantArt being a art platform where people can share art that made their data available to these AI companies. The plaintiffs accuse the defendants in this case, accusing these AI companies of copyright infringement by including their work in a data set. So exactly that question we're asking, is it infringement just to incorporate it into a data set? And the judge found direct and induced copyright infringement claims were plausible. That is to say, it could be, sure. So they allowed it to move forward. Their theory is that the AI product itself is an infringing copy. That is to say, the model is a copy because it embodies the transformation of the plaintiff's works. That is to say, by incorporating into the data set and then including it as latent images, which is part of how the data set is indexed, it is infringement. And that by distributing the AI product, your Midjourney, your Stability products, your Stable Diffusion, it is equivalent to distributing their copyright works. And remember up earlier, we said that the right of distribution is one of the rights of copyright that we like to protect with the law. There's no conclusion yet, but a trial is scheduled for April 2027. And we're going to see that throughout this. There's no conclusion yet. There's no, yes, it is infringement. No decisions have really been reached yet. And in this case, Sarah Anderson, is a comic artist. She's one of the plaintiffs, the one that the name comes from. And on the left is one of her comics, and on the right is one of the comics that was output with Stable Diffusion when you ask it to do a comic in her style specifically. So you requested Stable Diffusion, hey, I want something in Sarah Anderson style. And it's still crude, to be clear. But I'd like to remind you again, this is still the early days for this technology, and things will only improve from here. And this is where for further reading, I recommend reading this piece that she did for the New York Times, which is called "The Alt-Right Manipulated My Comic, Then AI Claimed It." And that piece is where the title of this talk comes from, because in it she says, after looking at this image, I see a monster forming. And it is a monster, I believe, that we need to grapple with sooner rather than later. For the next case we're going to look at Getty Images versus Stability AI. And I really like this case here because we can see in this picture an image generated by Stability's model. You can say, oh, yeah, it's just they could have used any old historic photo. It's not necessarily anything from Getty Images until we expand the full image and we see this little watermark here for Getty Images. So it's pretty apparent where they got their data set from. So in this case, Getty Images accuses Stability AI of infringing over 12 million photographs along with their captions and metadata. Remember how before I said that you have a bunch of images, but you need to index and tag them so you know this is a picture of an apple. Yeah, they took their metadata or those tags while building Stable Diffusion. So they also, as such, include claims of database right infringement, trademark infringement, as you can see from Getty Images, and more. Getty claims that the images themselves are infringing because they reproduce substantial parts of their copyrighted works. If you input historic images from specific times, you can get pretty close to actual images in Getty Images database. This case is also still ongoing in both the United States and the United Kingdom. There was recently a decision in the UK that has to do with the fact that Getty was representing a massive group of copyright holders as the representative of this class. They were saying, oh, we're representing all copyright holders. And the decision in their case was basically, hey, that's too broad. And that just really illustrates the scale of these models' infringements, if there are any, because it is impossible to identify all infringed parties. We don't know how much they're infringing when they create this database. If they're infringing at all, how much is being incorporated into this database? So Stability AI, they could know what copyrighted works are in its database. They have full access to it, but they have yet to identify how many images from Getty's website were used to train Stable Diffusion. Like I said, this case is also still ongoing, no trial date here. And this one we got an update on last week. It is New York Times versus OpenAI. Now, up until now, we've been talking about visual, lots of images that have been scraped and put into a database. Here we talk about text. So the plaintiff is the New York Times, along with other publishers. They are suing OpenAI, claiming that they exploited their content without permission or payment. It's pretty straightforward. They put all of their articles, all of their content into their model being ChatGPT. They claim that they're one of the biggest sources of copyrighted text used to build ChatGPT, which people have used, people have experimented. How does it predict what comes next? By having a lot of human written text, many of which is protected by copyright. OpenAI claims they're using publicly available data in a way that would be considered fair use. So that's their argument that, hey, we're using this for research purposes, is their argument. And the scope of the case was narrowed to only the copyright claims, but the main copyright infringement claim is going to move forward. The trial date has not been set yet. They're in the discovery phase of the trial, so we're still moving forward with that. And I mentioned earlier at the top of this presentation that when I was in high school, I wrote about the question of, will computers ever be able to write music? And at the time, it was very different. It was very much a research question. It wasn't a product they were looking to sell yet. It was a research. Can we do this? And the data they were scraping was largely of long dead famous composers, your Mozarts, your Bachs, your Chopins. Now it's very different. Those works weren't protected by copyright. These are, so we have to start grappling with these questions now. And if this is infringement, if the use of these images, of this music, of this text, of whatever artistic works is determined to be infringement, I'd like to highlight another problem that I don't see a lot of people talking about, and that is the black box problem of infringement. So, a black box is a system that can be viewed in terms of its inputs and outputs without any knowledge of its internal workings. Something goes in, something comes out. What happens in the middle, we don't know. Very often, computer programs or things like that can be considered a black box. You don't know what's happening in the middle. Generative AI is this black box. You can't see the inner workings of the model. And quite often, even the creators, unlike most programs, it's not really a if then else sort of coding thing. It's a database, it's machine learning. They couldn't tell you what's going on the inside. They often couldn't tell you what images or parts of the data set are being invoked. So how much infringement, if it is infringement, is happening inside of the box, you can't possibly know. And if you're using generative AI in your work and then it is determined to be infringement, are you now therefore infringing? And if you are infringing, how many big problems are that creating for you? Not just copyrights we're talking about, but trademarks, which trademark holders have a much bigger obligation to protect. If you're using these models in your work, you could be infringing on some very big company that is very eager to sue and has the resources to protect their very valuable IP. The very classic examples here would be Disney or Nintendo. They're companies you don't want to mess with. You can't know what you're potentially infringing on. It's inside of a box. Is there a trademark being included in your nice image that you're using in your game? You wouldn't know. So, with all of that in mind, the Copyright Office is doing a report in the future. They've done a number of reports in the past. We're going to talk about some of them in a little bit, but they're doing part 3 of the report, which will come out soon. No date is no, and it will address the question of training of AI models on copyrighted work, licensing considerations, and allocation of any liability. All of that is to say, questions of infringement, allocation of liability being that black box problem we talked about earlier. If you're using it, are you infringing? So stay tuned for that. Part 3 is still coming. We have part 1 and 2. So with all of that said, and I don't see anything in the chat for questions, so we're going to keep moving forward. Again, you can type in there or we'll address them at the end. What about copyright for the generated work? So you made something with AI. How's copyright work for that? Well, this is part 2 of the Copyright Office's report, which was released in January of this year. Part 1 was the first part. It was published in 2024. It covered the idea of digital replicas or deep fakes. It is beyond the scope of what we're going to talk about here, but we'll mention it. And this report that was released, part 2, seeks to clarify some of the questions around copyrightability of works created by generative AI. So the first big thing is copyrightability requires human authorship. So this is their quote, that courts have been called upon to explore and analyze the nature of authorship. As authors have increasingly used technology in the process of creation, the relative roles of humans and machines can be central to the analysis of copyrightability. When they talked about this was actually in the context of photography and whether or not photos could be copyrighted, which now we just accept, of course they can. A work for an AI created by an AI model does not qualify for copyright protection on its own. Copyright law only protects works that were created by a human author. An author can be assisted by an AI model, is what they said at the Copyright Office. Where exactly the line is between it being created by an AI model versus being assisted by an AI model is a case-by-case question and will depend a lot on your workflow. AI content based only on text prompts is not copyrightable ever. They said they were open to exploring this in the future if prompts or if AI models start giving users more control with their prompts, but at this time there's simply not enough control given by a prompt in order to give you control enough to be considered a human author. And this photo here shows a prompt and the output. It's from the Copyright Office's report. Notice that even though the prompt is really detailed and descriptive, there are still elements of creative expression that the AI had to interpret and add. Although this description, this prompt is very detailed, talks about the lenses, talks about the lighting, talks about the resolution a bunch. It didn't mention a lot of things that are here, the breed of the cat, the human hands. Those are elements of expression that are beyond the human prompter's control. Now, you might think that the question of art that is created by non-humans is a new thing, that the Copyright Office had to say, well, we have to come down to a decision now. only humans can have copyright. No, this actually isn't new. And now we get to talk about one of my favorite questions, favorite cases, which is the case of Naruto versus Slater. Because we've addressed non-humans in copyright before. Pictured here is Naruto, the crested macaque, and David Slater, the human photographer. Slater is the one on the right, and Naruto is the one on the left, in case you were confused. So Naruto v. Slater, it's pronounced macaque, is the monkey selfie case you may have heard of. Naruto the Crested Macaque took a few photos on a camera that Slater had set up, and PETA sued on behalf of the macaque, claiming that it owned the copyright, and the macaque was the creator. The court ruled for Slater and said that copyright law only protects the fruits of intellectual labor that are founded in the creative powers of the mind. This also does not include works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. Copyright only protects human creations, not those made by monkey or machine. And one of the reasons why this is one of my favorite cases is it comes up a weird number of times recently with new technologies, not just for generative AI, but there are other contexts where this has come up. To be eligible for copyright protection, a human must create the work. Are there questions? Okay, cool. So another case that gives us a more practical example is this comic called Zarya of the Dawn. So Zarya of the Dawn is a graphic novel that used images generated by Midjourney, which is a generative AI model. That was not disclosed during the copyright registration process. They just applied for registration and used generated AI images as part of the comic and just didn't mention it. When it was discovered, the Copyright Office retroactively canceled the copyright on it and a more limited registration was issued. So we're not just speculating on, oh yeah, Naruto v. Slater, that should apply here. No, the Copyright Office has done it as a matter of policy. But they issued a more limited registration that covered only the text and the selection, coordination, and arrangement of text created by the author and artwork generated by artificial intelligence. That is to say, it covered only how the images were arranged and the text, but not the art itself. And if that seems like a weird distinction, it is. Copyright sometimes is just weird like that. But in general, if you're a creator, this is a situation you want to avoid. A copyright in an entire work is much better for a whole bunch of reasons. You don't want a situation where you have copyright over part of a work. So an attempt at a simple explanation of what the Copyright Office decided, only human-authored works can be protected, and how much human creativity is required is a case-by-case question. Where you can or cannot use generative AI in a workflow, that's a discussion you should consider having with your lawyer, but prompts alone are not enough control to be protectable. So if you're using prompts and that's the extent of your control over the creative work, that is certainly not protectable. And finally, sometimes that means that only certain parts of the work will be protectable, and that's something you want to avoid. So let's talk about that case by case a little bit. How much AI can you use and still have a copyright? Generated by prompts, never protectable, no matter how detailed your prompts are. That's the first baseline. That's probably one of the only bright line rules we have. It was compared in the Copyright Office's report to commissioning a sculpture. The person commissioning the work doesn't own the copyright by default. You need a contract that would make them the owner for that. No matter how detailed you commission your work. Using generative AI as a brainstorming tool should not affect the copyrightability as the human authored work. So bouncing ideas back and forth with ChatGPT is something some people really like to do. I've never found it effective personally. That shouldn't affect the copyrightability of your finished work, assuming that you're using it as prompting and referencing rather than incorporating the input. You can't just take it wholesale. You do have to reference it. And again, it's a case-by-case question. Yeah, it's analyzed on a case-by-case basis. There is almost never, when they're looking at this, a hard line, a hard rule, or a bright line. It is very dependent on how your process works and how you're using generative AI. Human creativity does have to be at the heart of every step in your process. Your artistic process has to be driven by creativity, not by generative AI. In most cases, humans will be involved in the creation process and the work will be copyrightable to the extent that their contributions qualify as authorship. And anytime it's in quotes, I'm pulling that straight from their report. If you're using it to skip parts of the creative process, you might have problems. If you're using it to not be creative, that's a problem. If you're using it to assist creativity, maybe, depends. It's a case by case question. And yeah, consider talking with a lawyer and walking them through your creative process and getting an opinion from them on how much creativity you're using, how you're using generative AI if you're relying on it. So with all that said, we're going to go into the consequences for artists. What does this technology mean for artists? And many times it can cheapen the value of actual human artists and creatives. We have to remember what this is all built on. Artists. It's built on generations of artists honing their talent, developing their skills, and that's getting incorporated into a data set. And without that, if artists disappear, we start to have problems. This whole generative AI thing stops working. Bad data in, bad data out. It also has the potential to take actual work away from artists. Why would you hire, if you're a big company, an artist when AI can do a good enough job? It can make your product look cheaper in quality, but will the actual customers really worry about that? Will they care? Does it matter to customers? I This circulated last Christmas in the Portland Indie Gaming Game Squad Discord server, and it is an almond roca tin that was very clearly generated by AI. There's just a bunch of telltale signs that it was generated by AI, and they pretty shamelessly just slapped it on their product. They could have hired an artist to do a piece for their holiday tin, which would have been an opportunity for artists to get some work. It would have been an opportunity for them to have their work disseminated out there on holiday tins everywhere, but they decided to use generative AI instead. Does that reflect well on the product? Is it good enough for what it's being used for? It can cheapen the value of actual artists, and that's a real consequence that artists have to deal with. There's also the big consequence of copying an artist's style, because that has big implications for their careers. It potentially confuses clients and others on the outside when they search your name and come back with generative AI pieces. And art communities already have pretty significant problems with plagiarism. So automating that process probably isn't good for anyone. We mentioned earlier Sarah Anderson, and that if you asked for something in her style, it was able to return something in her style. That very much still happens. This picture is from Okay, I looked up how to pronounce this. Greg Rutkowski, who is a concept work artist, and he's worked on a lot of very big games. He's worked for Ubisoft, he's worked on Dungeons and Dragons and Magic the Gathering, and yeah, that shows in the art style. His work is on the left. Midjourneys is on the right, and it's being prompted, hey, I'd like something in Greg Rutkowski's style. And the article on this talks about this artist is dominating the AI world, and he's not happy about it. Many of the fantasy works generated by AI are based on his works, and people are asking for it in his style, and they're posting quite often, oh, this is in the style of Greg Rutkowski. And if you search for him, you'll often get generative pieces generated by generative AI. And that's a real consequence for an artist. It confuses artists. The quality is just not a match here, and you don't want this coming up when they're looking for your portfolio on the left.
Yeah, and Jacob, there's a question coming in about what just happened to Studio Ghibli with the big wave of artwork that was generated with 4.0 last week.
Mhm.
Like, are they filing lawsuits?
So I haven't heard anything about a lawsuit, but I also have not looked into it. I know Miyazaki himself is not a fan of generative AI or AI tools in general, famously not a fan, but I don't know that there has been a lawsuit filed at this time. They are a Japanese company. They would invoke Japanese law where the threshold to infringement is generally, like, I'm not super familiar with Japanese law, but I do know the threshold to infringement is much higher, but the fair use defense does not exist. So it would be a very different question. I'm not sure. And I do think is it Ghibli or Ghibli? I've never, the Miyazaki thing is interesting to me because it is OpenAI with their 4.0 model doing it, but it really highlights that their model, as much as they'll advertise it, can't do everything. We talked about general AI. They are basically running it through another model in order to generate images. So it's not one model doing everything like they're advertising. They're running it through a different model.
Hmm.
But that's an aside about how the technology works. I would not be totally surprised to see them file a lawsuit at some point or join in a lawsuit. I don't know. Nothing, I have not heard anything at this time.
I think that the interesting thing with this too is a question of scale. In other words, it's very hard to go after OpenAI for the part that they're doing in this. But if somebody generates something in the house style of a studio
Mm-hmm.
like that and then makes money on it, it might just be easier to go after someone smaller for copyright infringement, right?
It could be. It
So
could be. The
it just,
problem there
yeah.
is you'd have to, if you went after somebody smaller using OpenAI, you're not really cutting off the root of the problem. And also, you now have to prove that not only is it infringement to incorporate it into a data set, you have to prove that using that is secondary infringement. And that's not a settled question yet either. We haven't settled either question, but now you're asking multiple questions.
Mm,
But the question of scale is very interesting because you have to make these models with trillions of images, so many images. But it's very hard to show that your images are in there. Even if you had access to the data set, good luck finding your image.
mhm.
There are tools out there to kind of detect, hey, have I been incorporated into an AI model? But when you ask for something in the style of Ghibli, when you ask for something in Miyazaki's style, I don't actually know how it's pronounced. I legitimately have heard it multiple ways in the last few days. When you're asking for something in Miyazaki's style and you get something in Miyazaki style, it could serve as evidence that, yeah, Miyazaki stuff is in there. So does that make sense?
Yeah, it sounds dicey.
Yeah, it's tricky, which gets us nicely into the next thing. How do you protect yourself from all of this? So the big thing I feel is if you're contracting with an artist, have your lawyer consider provisions that specifically call out the use of generative AI. You need to be communicating with your artist to make sure you understand their workflow and they're not relying on it when you don't in a way that would be detrimental to you. You don't want to infringe or get yourself in a situation where your work is infringing or where you have an incomplete or unclear contract on it. I have started, when I draft the contract for a client, I've started adding this. I've added, hey, you represent that you're not using these tools in a way that would create problems for me. And if you're using generative AI in your workflow, make sure it's actually being used as a tool. I keep hearing, oh, AI is just a tool. Well, make sure you're using it as a tool and not as a substitute for human creativity. That still needs to be the heart at every step of your creative process. And if you're an artist who doesn't want their work incorporated to an AI model, that's really tough. You can opt out, but it's more like a polite request rather than something with any force, kind of like the robots.txt on a website, which kind of says, hey, robots, don't crawl this page. It's more like a request, really. Is it actually infringement to incorporate your work into a model? That is an ongoing legal question. So take action and make your voice heard where you can. And consider there are other tools you could be using outside of the law. There are watermarks, there are anti-AI tools like Glaze and Nightshade you can look into. And of course, make your voice known wherever you can. And if somebody is infringing on your work and you're worried about that, there's a presentation that's happening on May 1st, put on by OVLA. You can go to oregonvla.org and you can register for that. It'll be on May 1st. They're talking all about other people infringing on your work. So go check that out too, because that's important to understand even outside of the generative AI context. So as we look towards the future, it's important to remember the monster is still forming. It is not fully formed yet. The law is still being decided. It's only going to improve over the time. All of these images we've shown today, they're pretty crude, they're pretty simple, they're not great, but they're only going to get better over time. And these are questions, all these legal questions, legal implications. We need to understand them as artists, understand how the technology works, and we need to kind of figure out what we're going to do as a community as well as a legal group. There are still many other small questions that we haven't addressed yet today. Among them are the question of secondary infringement, the idea you brought up of going after the small user of OpenAI rather than the main one. What about licenses for the actual AI model? You know, if you're using an AI model, what kind of license do you have over the generated product? That's something you need to figure out. Are you unwittingly creating deep fakes when you're generating images? If you ask it for a picture of a crowd and somebody's pictured in that crowd, or you ask it for a person in a specific pose or wearing specific clothing, are you actually generating a deep fake of a real human whose photo is in that data set? Laws are now being created surrounding this, and they do not look favorably upon deep fakes. Once again, remember, the monster's still forming. We're still deciding the law on a lot of this stuff. Thank you all for attending this presentation. We're going to answer some questions. My name was and still is Jacob Vella. You can find me at my website where I post about all sorts of developments related to law, technology, entertainment, and games. You can also set up a consultation with me there, or you can reach out directly via email. Yeah, I think that about does it.
Thank you so much, Jacob. We do have some questions coming in already. So a number of them came from Seth.
I see them.
Yeah, the first one is like, what about other use cases, like using AI to rig 3D models?
Let me start from the top. So let's go one by one here. So other uses. I mentioned that general AI is not really possible right now. At any time you see an AI model that does anything, you should ask yourself, what data is being used to create this AI model? From there, any use case can be addressed. Are we just using, hey, this is how models are typically rigged? That's honestly probably a tool being used to assist creativity. It might not even be AI in many cases. That might just be a good old-fashioned algorithm. So any one specific use case, ask yourself, what kind of data went in? Is that data protected by copyright? And are we replacing artists? How does using, say, the blur tool in Adobe differ to having a tool add or change the value of your work? You know, same question. Is human creativity at the heart of the thing? The blur tool in Adobe is fundamentally just an algorithmic thing that alters pixels. Is it replacing AI human authors? And what kind of data set is being used here? That's the questions you would ask for any one tool that claims to be AI. And any thoughts about competing against countries that don't care about our laws? Not a new question. Exactly the same as how we protect copyright the same ways. It's complicated and it depends. It's a big question that I am woefully and inadequately qualified to answer on my own. But we have copyright and we don't stop enforcing copyright because another country doesn't follow our copyright. The United States has copyright laws, and we're actually very good at exporting our copyright laws to other countries. We put in effort even though other countries may not always respect them.
We have a number of other questions that have come in around like, do you always know when you're using AI, or are there tools now that are incorporating it in ways that we don't even know about where you might find yourself doing something inadvertently?
It's scary. Hopefully you do. And it's just make sure you understand the tools that you're using. If it's doing something that's too good to be true, you should probably be asking, wait, how's it doing this sometimes? But remember that if you're using any tool as a tool, to facilitate human creativity, you're not going to have problems as far as copyright protection goes. If you're using those tools, I mean, the secondary infringement things, that's a different discussion. But as far as copyrightability goes, use it as a tool to assist creativity, not as a substitute for creativity. Again, that's kind of a case-by-case question. It's really hard to address as a blanket question.
I'm assuming that the answer to the next one is no, because I haven't seen a lot of this. But there's a question about whether there's any sort of required disclosure for work that's created using generative AI. Like I've seen a lot of stuff floating around that is clearly Gen AI that is not identifying itself as such. So
Yeah, and for that, it would depend on the specific service. Is there a requirement? Who would be imposing that requirement? It would depend on where you're uploading and what you're using. I can think of off the top of my head two good examples of that actually. Um, do I want to switch my screen and show you? Let's do that. So the first one I can think of is actually, I want to say off the top of my head, I'm not super familiar with it, but DeviantArt does require it in some form. But the
But these would be
second one,
platforms where
yeah, they'd
artists
be
are
platform
uploading their work.
specific questions. Yes.
Hmm.
And the next one, I'm going to share it. Let's do it. Let's switch what I'm sharing. You all can see Steam now, right?
No, we still see the same
Oh,
thing.
I
You
have to
might
click
need
the
to,
share button. There's one more
there
prompt.
you go. Hey.
This is the Steam page where Steam is a platform for buying games. It's you can be a publisher here. You can sell your games on Steam. It's a PC platform. And this is the Steam page for Call of Duty Black Ops 6. And if you scroll down, we got this little AI generated content disclosure.
Hmm.
And they describe how their game was using AI generated content, as our team uses generative AI tools to help some in-game assets. And what exactly those assets are, I had to look into. It's one of the little banner images for some event or some item they were selling. It was like some zombies event or something. I don't know. I don't play Call of Duty, but they use generative AI to make it. Instead of hiring an artist or having one of the artists that they already had on their team do it, they just passed it through generative AI and they did that. So Steam does require disclosure. Steam as a platform has said, hey, we'll allow generative AI content for now, but you have to disclose what you're using and how you're using it to us, because Steam cares a lot about copyright and doesn't want to be caught in the middle of the crossfire there. So if the law changes, Steam is prepared. So I think that's an interesting example there.
Hmm. Yeah, not currently, but possibly future proofing, in other words.
Yes, that's how I think it is. They're definitely future proofing themselves.
Okay, cool. Next, there's a question about whether you think that some of what the AI companies are doing right now is trying to influence the approval of the public or even the, enlistment of the public and engagement of the public in and normalization, I would inject also, of these tools in a way that they're hoping will influence court rulings in the future. Would that actually influence court rulings? Would that be
I
effective?
I think that's their intent. Yes, that is absolutely their intent. So I mentioned that Sam Altman said that this wouldn't be possible without if they were required to pay for a license for every work that they're incorporating as their data set. Silicon Valley very much moves in a move fast, break things sort of way. And they're very much saying, oh, we've already done this. We've already let the genie out of the bottle. The monster's already formed. We can't put it back. Oh, well, there's these other countries that are doing it. We can't stop it now. It doesn't make itself. They can stop, they can think about how the law works. They chose to do it this way, and then they're very much trying to normalize it. Things like this Ghibli thing going out all over the place. I've seen friends post images in the style of Miyazaki, and I'm just thinking to myself, yeah, they don't understand what this actually entails. Most people don't understand. You all who attended this presentation now understand how AI models work better than most people. There are lawyers, otherwise presumably smart people, who think that AI models like ChatGPT are just really fancy search engines. That is not at all how it works.
Mhm.
So it's very much trying to normalize it, just trying to be like, oh yeah, anybody can do this. You can just make these images. So
Will that
yeah,
be
I think they're trying
effective
to
though, do you
influence public
think?
sentiment.
But will public sentiment be influential for the sort of legal rulings on these things?
It'll get it out there already. And once it's out there, they'll try to make the argument that can't be put back in. We've
Mm,
already done it. We can't undo it now. It's
hmm.
already out there. People are already using it. There's a reason you see it being integrated in all sorts of applications. Again, I think AI has its purpose. To be clear, if I sound super anti-AI, I'm there's a purpose, there's a time and place for it, but it has to be built ethically. And they're going to argue that they should be able to build it however they want.
This is a perfect segue to the next question
Okay.
from Maggie. Hi, Maggie, by the way. There are AI tools that are working to be responsible with inputs. And Adobe's a good example of this. I think it's Firefly in
Yes.
Adobe CC that's like asking for permission from artists in order to build those models and have people use the tool. Um, so you were saying many of those have much, much, much smaller data sets, but is it actually
Yes.
working to do some of what like Adobe in this case is trying to do?
Let's go back because I have my notes on this slide. So I mentioned that Magic the Gathering, a game that's been running for a ton of years, has 27,425 different cards. And we're going to assume, because I did round this data a little bit, that they have various drafts, various versions of every card that was not
Mm,
into the final version. if they took every single one of the cards that they own, all the card arts, and put it into a model, they would have 0.0005% of the Lion 5B data set. For that reason, or 1/200,000, for that reason, I have not seen a model yet that I feel comfortable saying, yes, this one is ethical, or yes, this one is functional, that this one was created ethically and is good. It's very hard to do. Adobe's Firelight might be one of the few cases of they just have so much data that they could probably produce something good, adequate. But the problem really is that these companies that are doing it ethically simply cannot match the sheer amount of data that data sets like the Lion 5B data set incorporate.
I
So I
will
have
say
not seen a
I
model that is good and I would say is ethical. Firelight, I have not looked a lot into to say, yeah, this works really well. But it's one of the few cases of they probably have enough data to do that.
yeah, I think it's Firefly and yeah, I think they're the way that they're getting opt-ins for that and then serving back results might be something to look at. I think also like it's interesting to think about brands that are training, you know, models on their own brand language in order to,
Yeah.
develop millions of product
Yeah,
descriptions or whatever.
quite often those kinds of models will be very narrow in their purpose for a reason. There's simply not enough data to be very general purpose.
Yeah. Okay, next question. If an AI company uses images that were created by an AI to feed their own database, would this be considered infringement? And actually, this dovetails with another question in my head, which is, isn't this going to be an Ouroboros eventually where the data is eating the data and it gets weirder and weirder?
All right, I'll touch on both of those in order. So first of all, I know the person asking this question, and they would ask a question like that. So thank you. So I mentioned earlier that images generated purely by AI are not qualified for copyright protection. If there's no copyright protection, then you can use it in a data set and not have problems. You don't need a license for something without protection. So the problem we would be getting at really is the first image. Is that infringement? And if that is infringement, using it in another data set probably would be secondary infringement. But if the first thing is not infringement, that first AI generated image, fun little quirk, you could then use it in your own data set and you'd probably be fine because it doesn't itself qualify for copyright protection. As to the Ouroboros, there's a funny little quirk of AI image, any generation, text, image, video, whatever. And that's that if I ask it for a picture of an apple, it creates an apple, but only kind of. There's flaws, there's imperfections, there's quirks. You've seen AI generated hands. They're wild. So little quirks and imperfections work their way into it. And if you start incorporating it into the data set again, those quirks and imperfections just become part of the training data. That Ouroboros does start to kill itself. So ironically, in trying to replace humans, you do need humans somewhere in the process to kind of filter it out and get rid of the stuff. Code is a good example where you have code that's mostly good generated by AI, but there's like a few parts that are like, that needs to be fixed. You incorporate that code by posting that online and then it gets scraped, those imperfections work their way in and then get added with more imperfections. So that's a very real problem we're already seeing happening, especially as people are posting AI into the world, AI generated content, and like we mentioned before, not disclosing it. So they're just getting incorporated. We're seeing that happen already.
Yeah. Okay, next question. What's the line for derivative work? So, given examples related to artwork by Warhol and other artists, like what actually would be considered, and is it a case by case, I guess?
It's a really complex question that is probably beyond the scope of what we're kind of talked about today and could probably be its own question itself. I have behind me a book on my shelf that is what I used when I took copyright law in law school, and derivative works were a big part of that. And what is a derivative work? Who can create a derivative work? What is one? It's a big question that's probably beyond the scope of what we can answer today. But I would encourage you to attend the presentation on May 1st at OregonVLA.org. You can register. And also, I would say the really, really simple answer for am I creating a derivative work is are you using somebody else's work? You need a
Knowingly.
license. Knowingly using somebody else's work, not being inspired by, but using somebody else's work, you're probably creating a derivative work. So
Yeah, and
at minimum, you're creating a derivative work.
this is a topic that we can also cover in a little bit more depth in future copyright
Yeah,
workshops, but it's a
yeah.
good one.
It's a big question that kind of goes beyond AI, but I will say this. One of the arguments that a lot of these cases are making against these AI models is that they are themselves creating derivative works in that they are taking the images and turning them into latent images, and they're arguing that's a derivative work, but also that the works being created out of those latent images could themselves be considered derivative works, but
Hmm.
unsettled question.
Yeah. Okay, next question from Seth. I'm seeing more and more platforms that are requiring us to accept their AI terms in order to use their products. I'm taking this to mean that they want to use our use of the product to train their internal AI models. Other than not using these products like Adobe, which we have to use, is there anything that we can do to protect ourselves?
I mean, it's not using their works, it's opting out where you can, or not using their products, it's opting out where you can. And we're seeing that more and more often. Sometimes when they have those provisions, it's written in a way that sounds scary, but is actually not meaning what you think it does. But that's pretty rare. And we're seeing it more and more. I know companies are looking to use training data as a revenue source. Reddit is in talks to do it because New York Times case showed us you need a lot of text to make ChatGPT work. They're talking about licensing their data to these AI models because it turns out Reddit is a bunch of text. So yeah, there really is not a lot you can do other than just not use their products, come up with alternatives, making your voice known to them, voting with your dollar by spending your money elsewhere, and opting out where you can.
Yeah, and I
Sometimes they'll
would,
have tools to opt out, but it's tough. There's not
yeah.
really an answer if you're locked in.
I would say like it puts a lot of onus on the user to opt out often. Like the defaults are not friendly, but if
No.
you care about this stuff and you're digging in the settings, sometimes you really in the spaces that are the most risky for you, where it's worth the investment of time, sometimes you can opt out in certain ways. And I really hope that those kinds of things are brought to trial, essentially for the good of the user,
Yeah.
that eventually that they will be forced to allow you to opt out more obviously in the same way that consumer protections kind of work generally.
Yeah. And I think that in order for that to really happen, to see that move forward, A, talk to your representatives about it, make sure that they know how you feel about it. But B, we almost have to establish that it's infringement first. It's tough. It's not easy. There's not good answers yet because the laws are still being made, and we need to make sure your voice is heard if that's how you feel about these kinds of things.
Yeah, it's a very sort of liquid time. Okay, last question I'm seeing so far. If a company releases promotional material that was AI generated, is that promotional material protected, or can anyone then use that material however they want?
Okay, so again, we get into the first question is it infringement for them to have created it? If so, you probably don't want to be using it lest you're infringing on the stuff in the database. So probably not however you want, but in general, the default rule is, yeah, if it was just created by AI, they don't have a copyright over anything at this time. So you probably can, but you also don't know what their process looked like or to what extent AI was used. So it would be irresponsible of me to say, yeah, if you see something generated by AI, you could just do whatever you want with it. They probably don't have a copyright, but they were themselves probably infringing to begin with, and you don't actually know the full process. So, but
Yeah.
the default rule, if you had perfect information, yeah, that's what not having a copyright kind of would entail.
Yeah.
But there's the infringement question. So
Yeah, so you shouldn't maybe
yeah,
take the almond roca container and go
the
wild
almond roca
with it.
container is the example that they clarify with. You don't know how it was made. You don't know where it came from. Yeah, I mean, by default, probably, but it's tough.
Yeah. Okay, well, if there are any last questions, feel free to pop them into the chat here. Otherwise, thank you so much for joining us. I will follow up with materials for you all afterwards and for folks that could not join so that they can access this information. Jacob, thank you so much. That was super informative.
Well,
And
thank you for having me.
yeah, really appreciate you.
Thank you.
Thanks, everybody, for joining.
That's one of those things that I enjoy talking about it. So.
Yeah. All right. I'm going to close things out. Thanks, y'all.